Good morning, everyone. I'm Suzanne Maloney, Vice President and Director of Foreign Policy here at the Brookings Institution, and I'm delighted to welcome you all today to the 10th Annual Justice Stephen Breyer Lecture in International Law. We're delighted to have so many joining us, both here in the audience in Falk Auditorium, as well as online, and I am particularly looking forward to what promises to be a very timely and important discussion. I would particularly like to thank the municipality of The Hague for their continued cooperation and support of this lecture series. We couldn't ask for better partners, and we are grateful for the support of all of our funders, not only for making our work possible here at the Brookings Institution, but also for the abiding respect for the value of our independent scholarship. Deputy Mayor Marielle Vavier, who also serves as The Hague's Alderman for Poverty, Inclusion, Public Health, and International Affairs, is here with us today, as is Birgitta Tazelaar, the Ambassador of the Netherlands to the United States. Thank you both for joining us, and we look forward to hearing from you in just a few moments. This year's lecture is on the United States, the West, and international law in an age of strategic competition. The idea of a rules-based international order has been shaken by Russia's brutal war in Ukraine, renewed conflict and humanitarian crisis in the Middle East, continued geopolitical shifts and realignments, and a year of pivotal elections around the world, including especially in Europe and here in the United States. In this moment of global upheaval and disruption, can Western countries uphold an international order based on the principles of the United Nations Charter? Is the current framework for international law adequate to govern engagement and confrontation between nations, as well as with non-state actors, or does it need rethinking? And how can multilateral institutions help preserve international law and ensure accountability in instances of violation? I am pleased to welcome Dr. Matias Spektor, whose profound insight and expertise uniquely position him to deliver this year's lecture and discuss the complex issues at hand. Dr. Spektor is Professor of Politics and International Relations and founder of the School of International Relations at the Getulio Vargas Foundation in Sao Paulo, a Brazilian higher education institution and a very top think tank in Latin America. Dr. Spektor was a visiting fellow at Princeton University's Institute for International and Regional Studies, and he is currently a fellow at Georgetown Americas Institute. He specializes in international security, political violence, transnational repression, and climate politics, among other issues, with a focus on Brazil, Latin America, and the Global South. Following Dr. Spektor's keynote address, he will be joined by my colleague Constanze Stelzenmüller for a brief moderated conversation. Constanze is the director of our Center on the United States and Europe and the Fritz Stern Chair on Germany and Transatlantic Relations here at the Brookings Institution, and she has led the organization of this lecture for several years, since taking it on from our colleague Ted Picone, who actually established it here at Brookings. Thank you to Ted, to Constanze, and the team of our Europe Center for such excellent coordination of this event. After the conversation between Dr. Spektor and Constanze, we will be joined by a very distinguished group of panelists to discuss how Western institutions have responded to the wars in Ukraine and Gaza, and what role the Global South can play in rethinking and revitalizing a robust international order based on the rule of law, transparency, and accountability. Let me introduce them very briefly. John Bellinger III is an adjunct senior fellow for international and national security law at the Council on Foreign Relations and co-chair of the Global Law and Public Policy Group at Arnold & Porter. Ona Hathaway is the Gerard C. Bernice Latrobe Smith Professor of International Law at Yale Law School and was the keynote speaker for our 2023 Breyer Lecture on Russia's aggression against Ukraine and the international legal order. We're delighted to have her back with us here today. Bruce Jones is our colleague in the Foreign Policy Program here at Brookings. He's a senior fellow in both our Strobe Talbot Center for Security Strategy and Technology and our Center for Asia Policy Studies. Our moderator today is Ishan Tharoor, foreign affairs columnist at The Washington Post and anchor of today's Worldview, the Post's daily column and newsletter on global politics. Before we begin, let me just remind you all that we're currently streaming live and on the record. We'll be taking questions from viewers, which can be submitted via email to events@brookings.edu or via social media using the hashtag international law. And now let me turn the floor over to several distinguished guests.
Thank you very much, Suzanne, and good morning, everyone. It's almost 10 years ago to the day that Justice Stephen Breyer stood here in the auditorium of the Brookings and delivered his first speech of a series of 10 afterwards in his name. And earlier this week, I stood in his office, an office that he called home when he served in the Supreme Court for 28 years, because I had the privilege to meet Justice Ketanji Brown Jackson. And she not only replaced him on the bench, but she replaced him in his office as well. And she really made it her office right now. So I stood there in the room where Justice Stephen Breyer spent 28 years thinking about really important decisions that affected millions of Americans. And I could see the Capitol through the window in his office and the same view that he had when he sat on the bench in court. And I imagine that view reminded him of the important balance of power between politics and the judiciary, a separation of powers that is so instrumental to our democracies. And while in that office and on the court, Justice Breyer was aware that the rule of law doesn't stop at the border, that international law plays an important role in our world. And in that first lecture 10 years ago, Justice Stephen Breyer analyzed 5 areas in which in which the development of law in other parts of the world has a direct effect on US judicial decision-making. And in doing so, he began his annual lecture series to explore critical issues at the intersection of international law, justice, and foreign policy. And it seeks to offer effective solutions from legal and policy experts, and policy experts that world leaders can implement in our increasingly interconnected world. The relevance of this topic has only increased, as we all know, since that first lecture, because the rule-based international order has become more contested in the last decade as opposed to before. So it's critical that we emphasize the importance of the rules-based order. And a rules-based international order. Today, Professor Matias Spektor will ask a question: can Western countries uphold the rules-based international order? And this order was established during a time of US supremacy, and now, obviously, we live in a more contested era. So is the current international legal framework adequate to govern engagement and confrontation between nations? The Netherlands is a strong supporter, I think all of you know this, of the international rule of law. And that's also why in the Netherlands, very recently, together with Ukraine and the European Commission, we hosted a conference Restoring Justice for Ukraine at the World Forum in The Hague. And right from the start, the international community has rallied to ensure justice for the victims in Ukraine and to hold the perpetrators of these crimes and violations accountable. But nevertheless, the bulk of the work lies ahead of us, and it will take considerable time and effort from the international community to support Ukraine's continued fight for justice during an ongoing war. But we need to remain united in our quest for justice in Ukraine. And it's not easy, but it is important. And sometimes what is doing worthwhile and what is most important is also difficult. But it's a test. It's a test to see if the multilateral institutions that we have relied upon in the last 75 years can carry us through to the next 75 and beyond. I'm really looking forward to the lecture, Matias. Thank you very much.
Good morning, everybody. This year, my hometown, The Hague, celebrates the 125th year anniversary of the first Hague Peace Conference. In 1899, some 100 delegates from 26 countries gathered for 3 months at the royal residence in The Hague. It was a major milestone. Standards for conflict resolution between nations were set, and it was the start of The Hague's coming of age as the international city of peace and justice. I am proud that many of the institutions set up in the last 125 years to uphold the international rules-based order are hosted by my city, including the UN International Court of Justice and the International Criminal Court. The City of The Hague continues to do its part to support the rule of law. Following the Russian invasion of Ukraine, the International Center for Prosecution of the Crime of Aggression is now operating from The Hague, as is the Register for Damages for Ukraine. The Hague also backs the ongoing initiative for the creation of an international anti-corruption court to tackle the abuse of public power for private gains by a nation's leaders. But there's still a long way to go. Events of the last 2 years show a decrease in respect for the rules-based international order and the current policies of the Western government that helped establish it. We see this in voting behavior of countries at the United Nations and other international fora related to breaches of international law. We see this in a lack of support for the imposing of sanctions against authoritarian regimes. In a year in which half of the world's population will be represented at elections, this is a huge cause for concern. I am therefore grateful to the Brookings Institute and the support of the Netherlands Embassy for organizing today's discussion, to allow for further reflection on what is needed for international law to continue to matter against the backdrop of these new realities. Are the standards, like those set in 1899, still up to date? Or are fundamental changes needed? Just as the Hague Convention and Peace Permanent Court of Arbitration were radical innovations in their time, there is now a clear need for innovations that make both international law and citizens more resilient. I am sure that this 10th edition of the Justice Stephen Breyer Lecture will be a special one, and that the speakers will give us plenty of food for thought. Thank you.
Good morning, everyone. I'm Constanze Stetzenmüller, and I've decided to change the order of proceedings. You don't need a fourth introduction, so Matthias, why don't you come up here? You've been introduced. We're all really looking forward to your lecture, and then you and I will engage in conversation. Come on.
Thank you, Constanze. And thank you, everyone, for coming. It's a real treat to be here. It is a great honor, actually, to be delivering the 2024 Justice Breyer Lecture. The list of previous lecturers is extremely inspiring, unless, of course, you're standing where I am, in which case it's extremely daunting. The requirement of this lecture is that the lecturer explores, and I quote, critical issues at the intersection of international law, justice, and foreign policy. And this is what decided me to try to say something about how we might think about the impact of great power change, great power competition on international law. The question I want to tackle today in particular is this: what's in store for the global legal order now that the West, for all its power and influence, seems to be no longer hegemonic? In other words, as we enter a new age of strategic competition, should we be concerned about the so-called rules-based order? And if so, crucially, what should be the precise nature of our concern be? Finding answers here, I think it's rather urgent at this time, because if you move in transatlantic circles or you read newspapers and magazines in the English language, you will find that there is a very specific storyline that is taking shape, and it's gaining a lot of traction. The bumper sticker version of this new story, which is not that new, it's a rehash of an older story, but in the new form, it could be the liberal West against the illiberal rest. The storyline is everywhere. It holds that the future of international law hinges upon the changing balance of power between liberals in the West and their various enemies. And these enemies include illiberals inside the West, the basket of deplorables, illiberal great powers, autocratic Russia, autocratic China, and the collection, the multitude of non-Western states, post-colonial countries that apparently devoid of any strong moral commitments are unwilling to take sides. They're taking the opportunity to hedge their bets in this changing global geopolitical landscape. This storyline is deeply influencing how we converse about the issues of the day. I mean, if you consider commentaries in the West about the war in the Ukraine, here's a narrative. As the West has levied these punishing sanctions against Russia, China's support for Russia has seriously complicated the enforcement of international law. At the same time, while the vast majority of developing countries have condemned Russian aggression in the UN General Assembly, they have refused to impose sanctions, which also complicates the implementation of international law. And if the post-colonial world is unwilling to punish such glaring violation of the principle of self-determination, which in theory they fought for such a long time, the argument goes, then it must be because either they don't really like rules, or because they resent the West somehow, or because they are beholden to Putin. And of course, add to this, in this narrative that is taking shape, there seems to be a readiness on part of electorates across the West to reassess their support for the Ukraine, potentially jeopardizing big time the norm of territorial integrity. We can turn to the war in Gaza, and you see the same narrative taking shape. In the aftermath of the atrocity committed by Hamas last October, Western commentators have found it challenging to interpreting the ensuing events. One issue has been, of course, making sense of South Africa's accusation of genocide against Israel at the ICJ. Another has been to make sense of the widespread support that the accusation has received from countries as varied as Ireland and Pakistan, so not just countries from the global south. Furthermore, many post-colonial states, as you know, have refrained from designing Hamas a terrorist organization. And add to this, Western societies, as you know better than I do, have been very deeply divided along demographic lines on the issue of Israel, further complicating the capacity of the international community to provide some sort of mediation. And although explanations as to what's going on these spheres has varied enormously depending on what you read, they inevitably circle back to this idea that there are changes in the global distribution of power and influence that could very seriously impact the global legal order moving forward. It's easy to see why the liberal West versus the illiberal West motto should be so attractive. The idea of a law-abiding Western community confronting rivals who are bent on upending the existing legal order is appealing in its simplicity. But today I want to argue that this mode of thinking is empirically inaccurate and it's politically dangerous. It's inaccurate, first of all, because it assumes that the rules-based order is an artifact of the West rather than the outcome of hard-fought political battles across cultural and regional divides. It's inaccurate also because it ignores the extent to which the West often hurts the very legal principles that it helped create, and the degree to which its officials have been willing to sacrifice core norms of the legal order when convenient. And the West against the rest framework is politically dangerous, I will argue, because it fails to acknowledge that winning the battle against illiberalism, both at home and abroad, will require a sort of liberal international, bringing together, connecting liberal voices in the West and outside the West. So if we are to properly protect the global legal order at a time of strategic competition between the great powers, we should retire the us versus them approach and come up with something better. So, to begin, I want to turn to history. I want to tell you a little something about the evolution of the modern legal order, by which I mean the codified norms, rules, and institutions that govern relations between states. And retelling this story from the standpoint of 2014, I think, is important because much of the contemporary debate, at least in this town, assumes that we are really talking about a Western invention. And this has a lot of problems attached to it. In the European order of the 17th and 18th century, the colonial system determined who enjoyed legal standing, who could trade, where migrants would flow, and whose culture would provide acceptable pathways for progress. By the late 18th and early 19th centuries, however, European dominance on the international legal system had come under very serious challenge. The challenge came by the countries leading the revolt, the United States and Japan, India and China, Haiti in the Caribbean, and the bulk of newly independent Latin America. Their legal opposition against empire opened the door to key struggles over freedom that would play out well into the 20th century. Think of the struggle for sovereignty and self-determination, for decolonization, for racial equality, for economic justice, for cultural liberation. From the 19th century onwards, this network of laws and legal procedures began to feature some very limited, but nonetheless very important, liberal ingredients drawn from the liberal tradition in political philosophy. For example, the idea that peace can be fostered by global wealth, and global wealth can be fostered by free trade. Or the idea that one should have formal limits on the use of force, and these should be crafted in ways that protect the weak against the strong. Or the idea that slavery should be banned and the rights of individuals should be protected by the international community. Or the idea that self-determination and sovereignty rights should provide a substitute for empire. And of course, there can be no doubt that first Europe and then the United States played a phenomenal role in setting up these liberal rules. But it would be a big historical mistake to assume that the resulting laws are the produce of their agency alone. Examples here abound of international law as a battlefield, and the legal system we now have is the result of these battles. So, in the wake of the First World War, for example, the victorious powers at Paris, to be sure, they laid down the roots of what would become the Covenant of the League of Nations. But one of the unintended consequences of the peace settlement was the global spread of the norm of self-determination in ways that Western countries couldn't control. In the wake of the Second World War, the victorious powers again created the United Nations. But the institutional design that emerged was the outcome of hard-fought battles over core principles and over the distribution of power and influence between the UN Security Council and the General Assembly. Similarly, if you want to understand the origins of the Bretton Woods system, no doubt American and British officials were at the heart of the design, but the actual implementation of these institutions we cannot understand without taking into account the degree to which they had to purchase support from the Latin Americans, which were bound to be their first clients. By the same token, the building of the US alliance system, both in the Atlantic and in the Pacific, is not a story of American officials deploying sticks and carrots to subordinate states around their cause, but of very difficult negotiations between a superpower and their weaker counterparts. Or take the Treaty for the Non-Proliferation of Nuclear Weapons. No doubt this was concocted by the great powers. It was great power collusion at its best to try and impose limits on the spread of dual technologies. But you cannot begin to make sense of the text of that treaty and the consequences of that treaty if you do not take into account the many years that it took the great powers to actually deliver a treaty that could be sold, and that could hold, and that could be so successful as to what we've seen. What I am suggesting to you is that what we call the rules-based order, and many of its liberal components, was not created by Western fiat. The global legal order has been built around these battles confronting North and South, East and West. The non-aligned conference at Bandung and the Suez crisis in the Middle East in the 1950s set the stage for countries to legally challenge empire, which was at the time a dominant rule among the major powers of the day. Resistance to Western dominance from Angola to Afghanistan, from Vietnam to Algeria, paved the way for many of the rules constraining the use of force today. The trade law that we know now is the produce of former colonial countries trying to ensure they could have sovereign jurisdiction over their commodities. And of course, we cannot begin to understand the world of the WTO without realizing how post-colonial countries had to unite to push back against not Western free trade, but Western protectionism. But there's more to this than that. If we turn to the human rights revolution of the 1970s and 1980s, how can we understand what happened and the turn under the Carter administration in this country without reference to transnational networks of global South individuals and global North individuals working together in the Hill to try and constrain abuse of power and try to constrain America's ability to support friendly dictators across the world. And the same goes for the neoliberal revolution. This is not going to make me popular with my friends in the global South. During the 1980s and 1990s, we saw Western reemergence. We saw dominance in multiple fronts, pushing for market reform, for deregulation, for selective democracy promotion, what have you. And of course, the United States in particular worked around the law to ensure it wouldn't be constrained by international law, that it could project its domestic law internationally, that it could apply it extraterritorially. Lots of changes there. But the fact is that the world that we now call, that era, the neoliberal revolution, we cannot understand it without the many connections between the Washington Consensus in Washington and its counterparts around the globe. This is not purely a top-down imposition. This is a process that, at the heart, entail deep involvement of transnational networks, of international panels and courts, and communities of central bankers, of scholars, of legal scholars in particular. The West versus the rest idea is therefore deeply problematic, I think, because, as I say, the rules-based order was not concocted by an enlightened liberal West facing a backwards illiberal opponent. Nor is this global legal order an example of an all-dominant master effectively controlling a helpless subordinate devoid of agency. In the pursuit of their own distinctive interests, states have weaponized international law, transforming the global legal landscape in the process. So the global legal landscape has been co-constituted by the West and the rest. This said, before we retire the us versus them story that I'm trying to retire, we must grapple with two very important issues that it brings to the fore, and we actually need to engage this quite seriously. The first one is this. Implied in the framework of the West versus the rest is the notion that the end of Western hegemony can seriously hurt the rules-based order, and more specifically, its liberal components. The underlying idea here is that there is a deep connection between the balance of power on the one hand and the changing character of international law on the other. The standard narrative, which is now being revived, is the notion that Western hegemony has been a precondition for the global rule of law and liberal rule of law at that. But is this indeed the case? I'd like to invite you to cast your minds back to the moment that best represents the height of Western hegemony, what we call the unipolar moment, that period between the end of the Cold War and the 2010s, when the United States was the only great power in the international system and the global legal order seemed ripe for liberal transformation. And yet, in the wake of 9/11, the war on terror taught us the bitter lesson that great powers, when unchecked by other great powers, by peer competitors, can break the rules of the game, and they can do an awful lot of illiberal things, even if they are liberal great powers. The policy decisions that followed 9/11 marked a major departure from the decades-long consolidation of the rules-based order. Powerful constraints on the use of force were appended first in Iraq and then in Libya. Liberal America debated the conditions under which torture can be legal, and how best to avoid accountability for targeting killings in foreign lands. The responsibility to protect doctrine revived arguments for international intervention that, to all practical effect, suspended standard conceptions of state sovereignty. And ideas emerged at that time that really revived things that had been dormant for a century. For example, the utility of protectorates for global governance, or the ideas that sovereignty can be graduated. Some countries deserve sovereignty more than others. Self-determination and human rights suffered enormously as a result of this period. Or consider the effects of the unipolar moment on global economic governance. The push for deregulation and the abandonment of the embedded liberalism that had been a feature of the global liberal order during the Cold War unleashed economic transformations and dynamics that are now fueling demands for lots of illiberal things: protectionism, mercantilist thinking, the abandonment of the WTO. So by the 2010s, the rules-based order was under serious threat, but the threat did not come from the rest. It didn't necessarily come from domestic enemies to freedom. It came from liberals, oftentimes unchecked. So it should be no wonder that in much of the world, including die-hard liberals around the world, these people should welcome the end of Western preponderance. The argument here is not trivial, and we don't hear it much, but pay attention to this. It's an argument made time and again in the 19th century, that if you care about freedom and liberty, but you are weak, then the balance of power is critical. Because when power is hegemonic, the strong get to throw caution out of the window and lay down the law on the weak. From this perspective, then, multipolarity can be virtuous precisely because it protects the weaker members of the international system. And indeed, there is a deep-rooted tradition in Western liberal thought, according to which the balance of power makes the preservation of freedom possible in the first place. Immanuel Kant. From this vantage point, the balance of power also contributes to the legitimacy of international law, precisely because it makes domination by the strong harder to obtain. So through this particular lens, the end of Western hegemony might potentially bode well for the future of the global legal order, and some will argue even for its liberal components. But of course, does this make any sense at a time when the alternative to Western dominance is illiberal, autocratic China and Russia? Can multipolarity be any good for the resilience of international law if the new poles of power are dictatorial regimes with no commitment to liberalism? Here, what I want to do is highlight a point that normally gets no attention at all in the contemporary discussion about the relationship between great powers and great power competition and the global legal order. For many countries around the globe today, and I would argue for the majority of countries around the globe today, there is no doubt that Russia and China are willing and they're increasingly able to revise and even break international law. They will break the laws they're unhappy with, and they will do this selectively. But I would also argue that to the majority of these countries, it is equally clear that neither Beijing or Moscow are willing to burn down the rules-based order. At least from a global south perspective, I would claim that the dominant view is that both Russia and China have used international law in recent years precisely to cement their ascent. And they've used the language and practices of legal argument to legitimize their growing authority in world politics. And they need to do this because they're not that strong. From this standpoint, neither Russia or China can be described as radically revisionist, even if, of course, Russia has illegally conquered territory and is conducting an illegal war, and even if China is challenging maritime law. So on this view, China and Russia, like all great powers, including the United States, will break the rules they don't like, try as much as possible to push for the rules they do like, and be hypocritical when justifying their ways. From such perspective, then, the option we're confronted to now is not one between a world safe for democracy versus a world safe for autocracy, but a world where the strong have a free pass versus a world where they are somehow constrained by checks imposed by peer competitors. Take, for example, China's relationship with human rights law. Beijing has developed a strategy aimed at redefining Western discourse on human rights, placing the state, not the individual, as the arbiter of rights and economic development as a core human right. By leveraging its influence in the UN Human Rights Council, China has sought to realign the Council's operational focus, to cultivate coalitions, and to advance resolutions that resonate with the Global South, while at the same time excluding critical NGOs. So this approach by China has sought to recalibrate the normative basis of human rights, recentering around sovereignty, non-interference, and collective rights. China has therefore weaponized international law and legal argument to advance its preferences, and in the process, it's challenging the West and it's challenging Western conceptions of human rights. But at least up to now, it's done this through existing institutions and existing forms of legal argumentation. And this has to be noticed because this is no longer the revolutionary China of the Maoist era that didn't follow any of these rules. China is investing heavily in multilateral diplomacy to remake international law to its image, and is working very assiduously, I'd say sometimes more than the United States, to garner either the support of the tacit acceptance of large chunks of the rest of the world. And this is far better than the alternative, which is war. There is a second issue that the liberal West versus illiberal West story brings to the fore, and we need to tackle head on. And that's the connection between culture, the West, and the present legal order. There's, as you know, a long tradition of thinking in international law that links the law to not so much to states negotiating international deals and agreements, but the law as the product of a shared community of values, rooted originally in Christianity and then in civilization. The so-called standard of civilization was at the heart of Western conceptions of the legal order well into the 20th century. It was, of course, used to justify not only territorial conquest and colonization, but also unequal treaties and the imposition of international legal norms that often undermined the sovereignty and the cultural practices of non-Western people. But it would be very wrong of us to assume that the standard of civilization is a relic of the past. The standard of civilization hasn't really fully died. In the 20th century, the view that rules and norms that sustain international order can hold or break along civilizational lines has been everywhere. Oswald Spengler, in his 1922 The Decline of the West, postulated the idea that the global political dynamics follow civilizational cycles. In the 1930s, Arnold Toynbee, in A Study of History, argued that the chief purpose of social elites is precisely to revive and fight for civilization in the face of its challengers. In the 1990s, Samuel Huntington revived this talk with his Clash of Civilization, positing that with the end of the Cold War, international conflict would be primarily around culture. And in 2010, Henry Kissinger, if you look at Henry Kissinger's On Global Order, the subtitle is The Character of Nations. The character of nations assumes that countries have particular cultural traits, and these are of the essence if you want to keep international order alive. So the West versus the rest is a rehash of this traditional story. We know full well there are many criticisms against this kind of talk, right? It's discriminatory. It serves to legitimize the subjugation of non-Western people. It imposes homogenizing models that ignore the wealth and diversity of political life. It's emblematic of injustices, so on and so forth. But the point I want to raise with you now is a different dimension, which I think is really important. One of the major problems with the idea of a standard of civilization is that it ignores the fact that liberalism has been a powerful force not only in the West, but beyond the West. That liberal voices have been prominent and deeply courageous in some places way outside the North Atlantic. And this multiplicity of liberal voices is normally lost in the conversation about the rules-based order, when it should not. So rather than fictionalize the differences between an enlightened liberal West and a backwards illiberal rest around the standard of civilization, should we not be pursuing a universal standard of truth instead? Wouldn't that be the proper liberal project? This would require us to go beyond our very narrow, petty, parochial interest, our narrow national origins, and our familiar cultural attachments, developing some ability to see the world through the eyes of others. And if we were to succeed, we might even conclude that if we condemn the indiscriminate use of violence against civilians by our enemies, we should be able to hold our own allies, our partners, and indeed ourselves to the same standard. In this lecture, I've tried to suggest that the liberal West versus the liberal rest concept that is now ubiquitous is reductive to the point that it limits our capacity to think about how to go about protecting the global legal order at a time of great power competition. I've argued that historically, the construction of the global legal order cannot be described as a Western invention, that over time brought on board the lesser nations of the world. I've also argued that the threats to the rules-based order do not come exclusively from illiberal actors at home and abroad, but also from unchecked power in the hand of liberals. And I've tried to make the case that liberalism is a rich tradition with a multitude of expressions way beyond the West. So to close, let me leave you with 4 thoughts. First, we must let go of the expectation that countries grappling with the evolution of the global legal order will coalesce around some kind of moral consensus. In a world of multiple centers of international power and authority, all we can hope for is heated deliberation, a lot of contestation, and, if lucky, uncoerced persuasion. A world where the major powers of the day confront each other in international institutions through the language and tools of international law is a good one, because the alternative is war. Second, the West is now confronting many charges of hypocrisy coming from all over the world. Hypocrisy, as we know, happens when a country's foreign policy is divorced from its stated principles, and the principles are couched in a language of moral superiority. For a long time, Western countries could afford to shrug these charges off, justifying their behavior by stating the fact, and it is a fact, that policymakers always have to make difficult trade-offs in real-world situations. The problem now, however, is that in a world of multiple great powers, being seen as a hypocrite becomes costlier, because those who feel victimized by hypocrisy feel more empowered to deny cooperation to the alleged hypocrite. It's more credible for them to deny this cooperation because they have alternative sources for global public goods or for private goods. In a more competitive world, therefore, the West might do well to consider a different response to the hypocrisy charge. Perhaps, rather than shrug it off, it should react through the politics of aspiration, specifying the measures it will and it can plausibly take to begin to comply with the self-professed principles that their behavior often violates. Third, in recent years, US policymakers to the right and to the left have signaled that they're willing to abandon many of the rules of the post-war order to compete with China and Russia. These may include the adoption of mercantilistic economic policies and abandoning the WTO, as I said. It could entail siding with brutal dictators as long as they are friendly, helping topple unfriendly regimes even if they've been democratically elected. It could entail letting go of arms controls. It could entail threatening the use of force. As we've seen, it could entail denying that UN Security Council resolutions are binding. For the majority of the countries of the world, this is hardly a credible commitment to the rule of law and to the liberal elements within the global legal order. And finally, in the aftermath of the Second World War, the architects of the Western order understood full well that their political project would require social engagement, active social engagement across the Atlantic. And as a result, they worked very hard to build transatlantic connections that could sustain liberal opinion in America, in Europe, and in Japan. But we haven't seen a similar effort to bridge the gap between liberals in the West and liberals outside the West. Of course, no doubt, American universities, think tanks like Brookings, and governments have long engaged democratic leaders, human rights activists, and legal scholars from a broad range of backgrounds. But there hasn't been any serious attempt at mapping and engaging liberal opinion in the non-Western world to ensure that both the content and the rhetoric that the West uses moving forward facilitates engagement rather than fuel backlash coming from the non-Western world. If illiberal social movements, as we know, are working hard to create transnational connections to help sustain them, should liberals not try and do the same, pushing in the opposite direction? For those who worry about the future of the legal global order, in an age of strategic competition, the priority should be to better integrate like-minded leaders from the West and from the rest. In sum, the simplistic dichotomy of us versus them did nobody any good in the unipolar era and is likely to do us no good in the currently multipolar one. Thank you.
Thank you so much for this. I am delighted that we chose you as our anniversary Breyer Lecture speaker. This was an incredibly rich and meaty lecture. And what has been particularly fun for me, and I think for my colleagues here, is to watch you develop your thinking over several drafts. Some of you who are sitting here know that we at the Center for the US in Europe feel that we have a reputation for culture and sophistication to keep up. And so we have a tradition that we call drinks and drafts, where we discuss a first draft of an essay or a lecture over actual drinks. And we had a meeting with Matias a couple days ago where we went through the first draft, and I see that what you sent us yesterday, you've been working on yet again between yesterday and today. In fact, I think sort of listening to you literally sort of argue your way through this, that you have the material for a book here, and I would be very, very pleased if you could continue talking to us about that. We have a little bit of time until the 11 o'clock when this panel will expand, and I do have questions, I confess. And let me start off with the first one. Again, I think it is incredibly helpful that you reminded us that the construction of the international liberal order can't be described as, you know, a Western vision of rules-based governance that was then sort of decreed or given to the rest of the world, right? That is immensely important. It is narrow-minded of Western liberals to think that they invented it all. And it's also good to remind us that occasionally liberal powers can act illiberally, right? I think we've seen a lot of that, and it behooves us, right, to take that charge very seriously and to respond to it gracefully and honestly, preferably without hypocrisy. But, you know, this week marks 2 anniversaries. the 30th anniversary of the 1994 Rwandan genocide, which I covered as a rather young journalist, in which the West, as you will remember, declined to intervene until it was too late. It also saw, this past week, the 75th anniversary of the signing of the Washington Treaty, which created NATO, an alliance which originally was intended to deter and defend against the Soviet, but ended up overseeing a series of Western US-led interventions in Bosnia, Kosovo, and Afghanistan. And I note that in your sort of list of things the West got wrong, you left all of those out. So my question is to you, in retrospect, were these decisions to not intervene or to intervene correct or flawed? And I mean, we don't have to go into every single one of them and every single aspect of them, but I would be quite curious to hear from you, because you only mentioned 9/11 and responsibility to protect, but these were slightly different cases.
This is great, actually, because you're pushing me to think through the things the West got right. And of course, the only reason why I didn't go into any detail is because you also gave me half an hour. But
the lecturers always say that.
I'm kidding. Absolutely. There are so many things, to be sure, that the West got right. And as I no doubt showed you during my talk, I'm one of the Global South liberals that I'm speaking about. So absolutely. So many of the rules that developed in the West and that emerged in the West were critical to protecting human life. I mean, I was born in 1977 in South America's most brutal dictatorship, Argentina. And, you know, thanking President Carter is not a dominant theme in my life because prior administrations had supported that dictatorship. But did it make a difference to the part of the world I'm from? Absolutely. So I would hate to leave you with the idea that I am angrily screaming at the sins of the West without recognizing the many wonderful things that developed as a result of Western interpretations of international law. But let me try and give you a slightly different approach to your question. Nietzsche used to say that concepts that can be defined are concepts that have no history. Concepts that have history cannot be defined because the definition is the object of intense struggle over meaning. So if we were to try and pin down what the liberal components of the international order are, and we were to run a survey, we'd get very different responses. Not only from Americans versus Indians, they would tell you a very different story as to what counts as liberal. But even within countries, Republicans and Democrats today would tell you a different story. And across generations, older people will tell you a different story than younger people. So it's very hard to have a single criteria whereby we can judge where liberalism got it right and got it wrong. The story you tell about Central Europe, thank goodness for intervention. And what shame that we didn't get intervention in Rwanda. My point is slightly different, is that at the same time that we recognize those genocides back then, and we can have books written about the inability of the West to act properly, sometimes we might repeat history, not acting now because we haven't learned the lessons of the past. You know, there are many people in this country that are arguing that what's going on now in Gaza is genocide. And without wanting to get into that fight, the fact is that when you look at the terms of public debate and official responses to this debate, one wonders, have we learned anything at all? So maybe my way out of your difficult question is to say, do we have a capacity of self-reflecting individuals to look back on the past and say, maybe at the time these decisions were justified, but are we making a mistake now on the back of what we learned from that experience back then?
All right. Thank you. That was a very thoughtful answer. I mean, we could go on for several hours digging into it, but I want to move to something else. I was fascinated by your idea, or by the world you sort of depict of a virtuous multipolarity, right? Where there are multiple legitimate viewpoints and where differences over rule are settled, to quote you, via heated deliberation, a lot of contestation, and if lucky, uncoerced persuasion. That's a really appealing vision, but of course, as you then later went on to say, that doesn't fully describe what's happening right now, because we are seeing coercion, right? And we are seeing coercion by liberal actors, both indirect and very direct. So the question is, how does this world deal with the most dangerous actors, those who act in malice, who deceive, coerce, and kill, for whom might is right, and how does a multipolar world without a hegemon address this challenge?
Great. So I guess the overall tenor of the argument I was trying to make is that you may need a hegemon to build up institutions, but if the hegemon is unchecked, then the hegemon becomes a threat to these institutions. So there is this tradition of thinking that says, well, you need to have constraints on the most powerful. And those constraints may not suffice to be the law. You may need to have other centers of power to counterbalance the hegemon. And that's what opens up space for the protection of the weak. That's the overall general argument.
But Matias, I'm talking about something else, actually. I think there are probably enough liberals in this particular room and elsewhere in Washington who are willing to say, you know what, we're fine with the end of the unipolar moment, right? And there were actually a number of Americans, I think, and American thinkers who were fine with it ending earlier than it did, right? Or would have been fine. What I'm talking about is something else. I'm talking about the great powers checking, right, who are doing so with an intent to achieve dominance of their own, and a dominance of a form that America never perpetrated, with all the mistakes it made, all the hypocrisy. You were talking about the world of Bucha and Mariupol, right? That is different, right? And how does your idea of a virtuous multipolarity, that's not that, right? How do liberals of the world address the existence of a Putinized Russia, right, that engages in killing orgies in Ukraine?
Well, okay. I think the answer to that is, first of all, containment. Containment is the only way out. When you have a member of the international community that is willing to perpetrate atrocities at this level, you need to push back through containment. If they're your allies, you need to credibly threaten them with suspending your support for them if they are, targeting civilians indiscriminately. It's a problem. What I find very problematic is to have double standards, is to have one take for Mariupol and a completely different take on Gaza, even if we can disagree as to the degree of destruction and the justifications for destruction, so on and so forth. Nothing hurts legitimacy in a multipolar order more than the perception of hypocrisy. So I'll give you an example that really mobilized me, and it mobilized my students in Brazil. Within the same month, we had Ursula von der Leyen chiding the Global South for not imposing sanctions on Putin for suspending access to water and electricity in the Ukraine, calling this a crime. And absolutely correct, it is a crime. And within the same month, there she was in military fatigues with the IDF at a time when, as we know, things there are a humanitarian catastrophe. In a multipolar world where most countries have alternatives, the crucial thing is that liberals need to commit to their principles and live by their principles. Sacrificing principles is playing the game of your opponent. You must not let the opponent win the day, because what the opponent wants exactly is to say the West is just cheap talk. All of the liberal stuff, it's trivial. When push comes to shove, it's force that matters.
Fair enough, Matias. I think a lot of us are probably willing to be very self-reflective on that point. And you are, in fact, seeing Western governments, including in this country, shifting their positions quite notably, right? Yeah. But still, I'm left with a final question that I want to throw at you before I depart from this podium. And that is, I'm intrigued, but also sort of mildly left wanting by the figure of the non-Western liberal, who is such an important witness in your lecture for your thesis that the international liberal order was not just created by a Western divine diktat, as it were. And you suggest that present-day liberals are an important source of legitimacy in this virtuous multipolar order. And again, granted that Western liberals have been and are guilty of double standards and hypocrisy, right? That's guilty as charged, something we need to discuss, but I do also want to push back. Aren't you, I'm not sure that we don't engage and don't map the non-Western liberals. In fact, my sense is that both Western governments and Western think tanks, experts like you and me, are quite desperately looking for these people, and in fact have Rolodexes with a lot of names on them, right? I mean, I was writing for my newspaper about human rights in the 1990s, and my Rolodex goes back 30 years, right? And I have kept in touch with many of them, right? But honestly, I feel that you're letting governments off the hook in the non-Western world with this argument, right? You're putting all the burden on these poor, liberals who very often are surveilled, beleaguered, are likely to, more likely than not these days to flee their countries and seek refuge in our countries, because they fear for their personal safety, right? Look at all the Russians who now live in Vilnius or in Warsaw or in Berlin. And so I ask you, shouldn't we also ask elites in the non-Western world, if we are willing to accept that we're guilty of double standards and hypocrisy? Hello, there is a war between Gaza and Egypt, right? Where are the Arab governments on this? Where are African governments on what are they saying about what Russian militias are doing in Africa, right? I'd like not to be solely held responsible for that. And that's my last question to you.
That's great. Wonderful. So a couple of things. First of all, I don't want to leave you with the impression that I'm arguing that the multipolar system is virtuous. All I'm saying is that multipolarity opens up a possibility for many countries of the world that wasn't there before. Whether it can be virtuous, to be defined, I entirely agree. I mean, I'm a professor of international relations, and international relations theory tells us that the most unstable systems in the world are multipolar systems, far worse than bipolar systems, far worse than unipolar systems. So multipolar systems, you run for the mountains, and I agree with that. But given that that's what we have, how do we deal with this? And the way to deal with this, I think, is to try and preserve the global legal order and ensure that countries will compete through the law and through legal argument more than they do through weapons. That's all my point. On the issue of the elites in the global south, absolutely. I mean, hypocrisy is not a feature of the West. Hypocrisy is widely distributed around the world. And, China and Russia are deeply hypocritical, and countries across the global south are profoundly hypocritical in their stakes. No doubts about that. Hypocrisy is not a bad thing necessarily. I think it was Harvard philosopher Judith Shklar who made the argument that in the world of politics, you need hypocrisy because hypocrisy is what allows differences to be reconciled. Far worse than a world of hypocrisy is a world of amorality. Try to imagine a president of a major nation who's amoral. That's not the world you want. It's much better to have a world in which the president says, well, no, we are committed to democracy, and, the summit of democracies, and then goes and shakes hands with a royal house in the Middle East. That's better because it allows critics to raise the flag and to push back. And that's all we can expect. On the issue of connections, of the transnational connections, I agree with you, but I'll leave you with this. I spent a year and a half in America recently on sabbatical leave. And one of the things that really struck me is that although I saw and attended, maybe 24 meetings and seminars on the war in the Ukraine, not one of them featured Russian liberals who've escaped the Putin regime and are living in the United States. And these people are there, they're sharp, they resist, and if we expect Russia to change moving forward, these are the people we should be talking to.
That's a really complicated topic on which we can talk at length, but we will, I'm sure, have you here again, to which I look forward. But now I'm going to trickle off this panel and hand over to Ishan Thoreau. Thank you so much, Matias. This has been wonderful.
Well, thank you all, and thank you, Constanza, and thank you to Brookings for having us. This has been such a terrific lecture so far. It's been really wonderful to read earlier drafts of Matias's speech, and then I think Constanza has already kicked us off in a very interesting set of reactions, and I'm sure that many of you here who have your own questions, and I will hopefully make time for you to get those questions in. Let's kick things off though, and we'll give Matias a bit of a break. Una, I'd love to start with you. After the passage of that UN Security Council resolution on Gaza that actually passed, where the U.S. abstained, you had White House officials describe it as non-binding. You had, and this is, presumably there is no greater body in the global legal order to determine these things than the Security Council. I'm curious for your reaction to that, and obviously this is a way to get into some of the themes that Matias was putting on the table here, but is it safe to say that we are now in a non-binding rules-based order?
No, I don't think so. Although it is true that quote-unquote non-binding agreements have become quite a bit more common. But I wouldn't say Security Council resolutions fall into that category. No, I mean, I think that what we're seeing is a rise of many different modes of trying to encourage states to abide by international law. Non-binding agreements are actually growing significantly. There's thousands of them every year being concluded by states, more so than binding agreements. But again, Security Council resolutions don't fall into that category. I mean, what we're seeing, and this is one place I think where, Matias, you have a strong argument. The United States holds itself out as a central player in enforcing international law, and yet it's not always prepared to live by those standards itself. I think Gaza has been a case where, rightly, there's been significant criticism of the United States for failure to hold its partners to the same principles and aims that it would hold other states in the world, most notably right now, of course, Russia. So, yeah, I mean, I think there's a long conversation to be had that is, I think, somewhat orthogonal to Matias's argument about the rise of non-binding agreements and the way in which there is increasing use of different forms of enforcement that don't look like traditional legal enforcement. And we're seeing that in Gaza. I mean, we're seeing that not so much through the Security Council resolution, but we're seeing it through the rising calls for states that are providing arms to Israel to cease doing so. And you're seeing this in Canada. There's litigation happening. There's litigation that is taking place throughout many countries around the world. The Netherlands there was a Netherlands case that determined that F-35 parts couldn't be sold to Israel because of international prohibitions on supporting Israel at a time when it was, in the court's opinion, engaging in violations of international law. And I think we're beginning to see a spread of those kinds of enforcement. You wouldn't call those exactly traditional enforcement in the way that we might think of Security Council resolutions being enforced, but it's a really important form of enforcement that is holding our partners that we engage in trade with to the same standards that we're holding others to. And I think that's actually a hopeful note here, and a way in which international law is being enforced in a kind of non-traditional way, but I think in a really powerful and ultimately extraordinarily important way. And, we'll see now the U.S., we saw Biden saying that he was, calling for aid, and this phone call that recently was had which suggested that maybe he didn't quite threaten that he was going to withdraw U.S. support or condition support, but something was said in that call that seems to suggest that it sort of lit a fire under Netanyahu, and he is allowing more aid in. So I think that this is a way in which states can bring pressure on other states to abide by the best principles of international law, and they are themselves, in fact, obligated to do so under international law, because under international law, draft articles of state responsibility, if you are aiding and assisting a state that's engaging in an internationally wrongful act, you are yourself engaging in an internationally wrongful act. So I'll leave it there.
John, you were in the White House as a prominent legal advisor at a time, I guess, in Matias's chronology of the unipolar moment. I'd love your reaction to some of the kind of takeaways that Matias left us with this. He said, we should let go of the expectation that countries grappling with the evolution of the global legal order will coalesce around some kind of moral consensus. He also suggested that in a more competitive world, the West would do well to actually respond to charges of hypocrisy. I'd love your kind of big picture reactions and thoughts to that.
Great. Well, loved listening to Matias, both conceptually and also some history. Let me get to sort of my bottom line point on this, was actually tease off your last point, which is about sort of talking about international law and then talking, and not just having the West talking to each other. I think there is a problem of international lawyers, and as you say, I approach this as a government practitioner of international law. I was the U.S. government's chief international lawyer for a number of years, and there's a problem. We do tend to just sort of talk to each other. The Western countries talk to the other Western countries, and we also only talk to other international lawyers. So we're very good at talking to other international lawyers at conferences and so forth. But two things don't happen. One, international law is not really infused at higher level conversations, except for, and the Dutch ambassador, one of our hosts is here, has been in a lot of these meetings, as I have. You're lucky if the words international law are sort of thrown in as a bullet point. You're lucky if you get that much. But foreign ministers, much less heads of state, are not talking about international law, in deep detail. The international lawyers talk to each other, but that doesn't trickle out. So when I was legal advisor, I pushed two things which I think we really need to continue to push. One is what I call international legal diplomacy, really talking about why international law is important and to all people, not just to each other. And we need to have more of a conversation between the West and the rest. And then the second part is international legal public diplomacy. So it's not just the lawyers talking to the lawyers, but talking more generally. And I'll sort of end with this point because it's a deep concern to me. I used to give lots and lots of public talks about international law issues and do really deep dives to explain the U.S. position on certain things. This gets to your hypocrisy point. And I was quick to say, look, here are some things that we have not gotten right. We recognize we disagree. Tell me your position, and to be honest about that. Right now, for the U.S. alone, we are at a distinct disadvantage because we have not had a confirmed legal advisor for 5 years. No legal advisor of the United States has given a public speech for 6 years. I used to give, and my successor used to give, a major speech probably every other month. So the United States right now is voiceless on international law. You're lucky if Secretary Blinken mentions the words, and this is not to be a criticism of him, but that's not what he talks about. So we are voiceless. The nominee to be legal advisor of the State Department is, in fact, a former Brookings fellow, an extraordinarily distinguished international lawyer who spent 10 years in the legal advisor's office, currently general counsel of USAID, but the Senate has been holding up her confirmation, so we have been voiceless as the United States, even to speak to the West, much less to the rest at any really significant level. So bottom line, we need to talk more in detail about international law. And I love the point that you ended on, which is to make sure that we are talking not just amongst each other, but cross-culturally, across the West and the rest.
There are a couple things I'd love to pick up on there, but let me just circle back to Bruce first. I'd love you to react to the conversation that Constanza and Matias had about multipolarity and its virtues or lack thereof. And you're somebody who I know has advocated a kind of robust revitalization of multilateralism, perhaps to a certain degree led by the United States. We'd love to hear your thoughts on all that.
Good, thank you. And I want to start by saying bravo to Matias for the lecture and the content. I'm hugely supportive of the overall argument, and I hope it's helped to drive a stake in the rest versus the West theme. I'm going to lobby my colleagues to have you back to sort of drive a stake in the very phrase rules-based order, which I think is badly distortive and deeply problematic politically. But here's my main reaction to your question and to the end of your piece. I think this phrase uncoerced persuasion is very important, and the notion that that's what happens inside multilateralism is important. But I worry that that's not what we're going to see. Or let me put it differently. I'm worried that the fight that we are now having within multilateral institutions, which we're having, it's a fight, right? The multilateral institutions have become a space of contest. And that's fine, and we should take that contest, and we should take it more seriously than we do. I've been a longtime critic of how anemic U.S. thinking and action in multilateral institutions is, and that the cost of that has grown. But it isn't the only fight, and I don't believe that the fact that we're fighting within multilateral institutions necessarily is going to stop us from fighting, per se. And it's quite possible that we are going to live in a world where the multilateral institutions under sort of pressure and contestation, et cetera, but we are also going to see dynamics that will take us to conflict and war irrespective of that. So unfortunately, we could be in a world of both things, right? And it goes to a kind of broader point that I'd like to make, which is that the part of the challenge in this space, and one of the reasons I loathe the phrase rules-based order so much, there are all sorts of things that happen in the world that you could describe as part of a broad sort of sense of multilateralism or broad cooperation, which are not grounded in international law or rules. There is not a single phrase, word, or comma in international law that says when there's an outbreak of Ebola in the Congo, the United States should send its premier health institution to help stop it. But we do. We do it all the time. And we do things like that all the time. They're not bound by international law. They don't speak to international law. They're not constrained by international law. They're just things we do in the world. And a lot of countries see them as positive. When we come to international law, I think our standing is much more complicated and much more difficult. And for me, it's sort of odd that the United States in the last decade or so has chosen this rhetorical frame that sort of focuses on that piece of multilateralism versus much wider issues. There's all these things that happen in the world which aren't described by international law, aren't described by multilateralism in the narrow sense, that bear on the question of our standing in the world, and I think have to be held in balance with looking at behavior within multilateral institutions. I'm very sympathetic. I've written the same sort of theme that China is not just ripping up the rules all over the place. It's trying to write new rules someplace. It's tearing down rules other places. It's working within the rules some places. And a lot of that is bad. And the fact that it's happening within the rules doesn't change the fact that it's bad, I'm seen from my moral standpoint or an American liberal standpoint. And there are things that we do within the rules that are bad. So, law or not law, within the institution, not within the institution, is not an adequate description. And I think that's the world that unfortunately we're going to live in. And then last, Ishan, to Constanza's question to Matias about how do you resist. I mean, it seems to me that part of the answer there, and you gave part of this, I think, Matias, it is perfectly consistent with the principles of international law, if not with every letter of the Charter, to resist aggression. Right? When the founding purpose of the Charter was to resist aggression, NATO was born as a way to implement Article 2 of the Charter with a subset of actors who, if there was not going to be consensus in the Council, which there's not going to be, you might have to do things which, strictly speaking, violate this or that provision, but in the kind of core principle of resist aggression has to be part of what we do. And I think that's the right sentiment for Russia. The challenge is it's not yet the right sentiment for China. Right? China is not undertaking aggression yet. But it's acting in ways that cause us to worry that it might, and that's, you know, the whole series of things that happen there. And so this very dangerous stuff that's happening in a, I wouldn't use the word multipolar world, but in a world of non-unipolarity, unfortunately, I don't think is going to be adequately captured by sort of narrowly described international law. It's going to have this wider sense of the dynamics of non-aggression.
May I speak in defense of the rules-based order? Okay. I think the idea of driving a stake in the heart of rules-based order just got me going there. I think that's a mistake. So the idea behind the rules-based order is the idea that there's a set of rules that govern the international legal order, that govern the behavior of all states, and that don't rely exclusively on the power that states have. Now, absolutely, there's critique that, you know, is this reality, you know, or is it kind of a vision that is not always realized in practice. But the idea that there's a set of rules that govern the international legal order, that structure our interactions with one another, that bind all states equally, that all states are equally represented within the rules-based international order, and that there's a set of rules that govern our behavior as opposed to simply it being boiled down to power, authority, might, I think is essential to the modern system and is essential to the post-war legal order, which is a rules-based order. And I don't hear you, although you should tell me if I've got this wrong, to be saying that we should throw the idea of a rules-based order out the window. I hear the critique more as a question of, first, on the one hand, a critique that to the extent that West versus the rest suggests that it is simply a project of the West to create a rules-based order is a misunderstanding, because it was a process of co-creation, that these rules are not simply a kind of dictated from on high by a certain set of states onto others, but that this process of creating these rules is a process of co-creation, and you can't understand the rules without understanding that process of co-creation. Absolutely agree with that. And then also a critique, here I'm not sure I'm fully with you, but I see the validity of the critique, a critique that the U.S. in speaking on behalf of the rules-based order is often acting quite hypocritically, is that violating the very rules that it seems to be claiming or arguing in favor of in one place is not then making the same arguments in another place and not holding it to allies. That's a fair critique, I think. The place where you lose me on the argument is that therefore, and maybe I misheard you, but therefore a kind of multipolar world where states that have where Russia and China, just to be specific, are sort of equally vying with the United States for authority is somehow going to cure that hypocrisy. And I worry a bit that the way you framed it suggested that sort of this peer competition is going to make it harder for the U.S. in particular to be hypocritical. And I'm not sure that's true, because if you're competing with states that don't necessarily have the same vision of the rules-based order and don't have the same kind of commitment to a world in which international law, at least in theory, governs, and yes, you know, again, I'm the first to call out all the failings, but have a vision of Mariupol or, you know, of a world in which, you know, it's fair game to engage in these massive violations and then refuse to accept the legitimacy of the international legal order. I'm not sure that that's a world in which that peer competition is actually going to lead to a better world for you know, for all of us, and not just the West, not just, you know, for the rest as well. So I guess that's where I'm not sure in terms of the diagnosis of what we do. I guess is so I'm with you up until the point where it gets to this question of what do we do given this hypocrisy? What do we do given this fact that there's this process of co-creation? But I guess I don't hear you, and maybe this will be a point that you might invite Matias to respond to. I don't hear you necessarily calling for throwing the rules-based order out altogether. And you know,
to be
I
clear,
myself
I'm not
think
calling for throwing out international law. I think the rhetorical phrase rules-based order is analytically problematic and politically disastrous. And I can elaborate on why, but that's not the point for now.
Okay.
Matias, do you want to respond to some of that?
Yes, absolutely. This is great. So, absolutely, the idea that international law is what protects the weak against the strong is a powerful one, and I wouldn't throw away the international law at all. The argument that has gained traction, I think, in the United States and in the West, when officials refer to the rules-based order, is a particular take on international law. And that particular take suggests that while we here are committed to rules, the others are uncommitted to rules. That element of the argument is what loses me, because from the standpoint of other countries, Western commitment to international law has been selective. And the way they portray their actions, I mean, if you talk to Chinese diplomats, or to Russian diplomats for that matter, they will produce these very long lists of instances in which they see themselves, genuinely, I think, as defenders of international law. The point is, who is there to judge what's proper and not proper commitment to international law if there is no supranational body capable of adjudicating? Countries will use international law not as a tool, but as a weapon. There's a lot of literature in international relations that describes international law as a tool for countries. I tend to see it more as a weapon. They will use this to fight. So my point is, in a multipolar world, we won't see less hypocrisy. If anything, we'll see more hypocrisy, because now that Russia and China are more powerful, they are going to attract an awful lot more of hypocrisy charges against them. Hypocrisy is all there is, but if hypocrisy is all there is, that's not that bad, because we have space for legal argument. We have space for pushback. The danger, I think, is when we begin to frame global politics around the idea that some countries embody international law and the others are so beyond the pale, they're such a threat to international law, that we begin to justify our own violations of international law because they're not committed to international law. I think that's really dangerous. And again, for a moment, I don't want to suggest that multipolarity is going to be more stable. Everything in my training tells me that multipolarity is going to be far more unstable than what we've seen. And my concern is precisely that if we approach a multipolar system, a non-hegemonic system, from the standpoint of we are those who protect the law and the other ones are the barbarians at the gate, we're going to push the international system into violence far more than if we take a more agnostic view and we challenge the hypocrisy in others by trying to curb our own hypocrisy. That's my sort of political vision, if you want.
Is it okay if I say one more? So I'm with you on that, but then I think one of the challenges that you face is that you talked in the early outset that, you know, part of this West versus the rest kind of misportrayal is that, you know, there's the Western sort of argument in favor of international law, and then the rest is sort of silent, or, you know, there's the liberal side, and then there's this kind of silent middle. And there is one answer to dealing with the hypocrisy problem, or at least to trying to get the great powers to be less hypocritical, which is for states to stand up more for the international legal order. And the honest truth is that a lot of states are quiet about what they see as the legal rules. And so if you look at, for instance, one of the major bases on which the U.S. uses force in the world is this idea of unable and unwilling theory, right? So the idea is if states are unable and unwilling to deal with threats of non-state actors within their territory, then another state is able to respond to the threat that's posed to them, and they can use self-defense against those states. There's only about 30 states that have a public position on unable and unwilling. And the majority of states who've taken a public position on unable and unwilling are the states that are using force. So it's the states that are using force that are saying, well, we can use force under this unable and unwilling theory. And they're using force under the unable and unwilling theory. And for those of us international lawyers who think, well, this is not a very good argument, actually, I don't think it's consistent with the history of international law. I don't think it's consistent with the proper interpretation of Article 51. But there's very few states that are willing to say, actually, we think that's the wrong reading of international law. And so it would be great if more states, if the rest, would come out and say, no, this is our vision of what international law actually is, and unable and willing does or doesn't. I mean, ultimately, I could be persuaded if a lot of states thought this was the right reading of Article 51, then I'm wrong, and that's great. But that silence makes this room for states who have the capacity to make the arguments that John was talking about, to really shape the law, and to shape the law in ways that may not always be positive. And so I guess part of this, would be to call on the states who see hypocrisy and encourage them to call it out and to articulate what is their view of what the law is or should be. Because that silence then creates space for the states that are more hypocritical to be able to take their positions without any kind of blowback or pushback. So anyway, this, I guess, goes a little bit to Constance's point, too, about, why don't we put some responsibility on these other states to actually take a position, not just, the West, not just calling out the West, but also calling in states to participate more in this conversation.
I couldn't agree more. Absolutely, 100%.
Bruce, you wanted to jump in, or just?
Yeah, a couple of thoughts here. So one is hypocrisy is one way of looking at the issue. The other is selectivity, right? Which issues do we choose to mobilize in defense of international order, in defense of international law, et cetera, right? Now, so from my experience, watching American diplomats and Western diplomats go to the UN at the beginning of the Ukraine campaign and be surprised that there wasn't this kind of rallying behind the West in critique of Russia. Part of my question to those diplomats would be, to what extent were your presidents and your whole system whipped up over the 300,000 people killed in Ethiopia the year before? Now, those are different kinds of wars. It was an irredentist conflict and then an internal conflict that didn't violate Article 2. Okay. But it was 300,000 dead. And, the West sent some diplomats. I mean, we sent Jeff Feltman to help deal with it. And we did. We sent some diplomats to help mediate. We didn't mobilize our massive national infrastructure to, try to deal with it in a major way. We didn't spend $55 billion a year trying to deal with it. So if I'm an African state at the UN and I notice this kind of massive pressure on me to kind of create problems with myself, with the Russians and the Chinese, I also wonder why the United States didn't care very much, really, about the 300,000 Ethiopian dead. And we can repeat that in sort of endless numbers. So there are different international law issues, but the selectivity is, I think, very problematic in the way that this gets received in the international system writ large. And that's it's a different framework than the international law questions. But I think it's very consequential to this argument.
So if I could do the crude journalistic summation of the gist of a part of your argument is that you see a certain mode of orthodox Western liberal internationalism as no longer serving us, but you're still keen for a kind of liberal internationalism. And the difference between the two, I think, is really interesting to explore. I'm curious, what does this mean for the institutions that do exist, that do underpin the current so-called rules-based order, whether it's the UN, whether it's the august body that's in The Hague, the ICC, these other institutions? And this is a question also, maybe John, if you want to weigh in as well. Given the shifting landscape that you've charted for us, where do the prevailing institutions that are scenes of so much discord and scleroticism and dysfunction in some ways, where do they go from here?
Well, first, I watch with some amusement. It's hard to be a practitioner on stage with a group of academics, but I will say one thing. I think on the rules-based order, I agree with Bruce on this, I think it is an unuseful practical label. Ona, who I've known for a long time, I think is defending the concept. Bruce is making a different point, which is Bruce is not against international rules, nor am I, but I think what we're finding is both domestically, but even more internationally, it is not a useful label. I mean, I certainly domestically would not go up to our Senate and say from the State Department, the most important thing we need to do is to defend the international rules-based order. I would get thrown out of a Republican Senate. Similarly, internationally, it's not much use to go and say, well, we, the United States, are trying to defend an international rules-based order for the reasons, Matias, that you've explained, is it looks to them like it is a Western order. And do I believe in international law and following the rules, and explaining to other countries why these rules are important for everybody? Yes, I do believe in that. On the institutions, international institutions are under enormous stress right now, primarily because of the Russia invasion of Ukraine. The Russian invasion is not the same as the Iraq war. I get the onus charges of hypocrisy, but nobody can say that these are the same thing. Russia has committed the grossest invasion of a country certainly since the creation of the UN Charter, and continues to do so every day. It is an assault on the population of a neighbor, and is continuing every day. So it certainly puts the UN Security Council, when a charter member continues to do that, under a lot of stress. I mean, we've been talking for a long time about what do we do when the Security Council is divided. We don't have an answer to that. We have had the General Assembly try to do some things, but that has not fixed the problem. We have worked through the two important institutions in The Hague, and there are many important institutions in The Hague, but both the ICC and the ICJ. The ICJ stepped up rapidly. I was proud of the fact that my former principal deputy legal advisor, Joan Donoghue, was the president of the ICJ at the time when they issued very rapidly an extremely important condemnation of the invasion. Can the ICJ force Russia to pull out of Ukraine? Obviously they can't, and they haven't. That doesn't mean, though, that they have no role. The ICC, this is really what the ICC was set up to do. That's why I have written and spoken extensively, despite U.S. historic concerns about the ICC, to say when the ICC is doing what it was set up to do, the U.S. should support it. We've got a new prosecutor who is doing the right thing, and I hope we'll continue it. So the point here, Ishan, is probably at the greatest point in the last 75 years, we have the major international legal institutions, the UN Security Council, the ICJ, now the ICC, all under enormous stress, and they are trying to rise to the occasion, and we need to try to support what it is that they are doing.
Matias, you want to react to that? I mean, I think there are. John, your point on the gulf between the invasion of Iraq and the Russian campaign in Ukraine, its ongoing invasion, is well taken. I would suggest there are many in the Middle East and in Iraq who see that as a distinction without much of a difference.
So let me just respond to that, because this actually gets to my original point. I mean, I hate debates about the Iraq War because I am not a defender of the Iraq War as a matter of policy. But this is Ona's point about hypocrisy. But one has to actually confront it. These are not the same things. Saddam had ignored the calls of the Security Council for years, ignoring the binding UN Security Council resolutions. He had been committing gross human rights violations against the Kurds. For 10 years, the UN had actually been authorizing the use of force against Iraq. And then there was a limited and short invasion of Iraq. The rest of it did not work out well, but it was brief at the time. Russia, on the other hand, has without any justification invaded a neighbor, attacked directly its civilians. It is directly attacking and killing civilians, and is doing that 2 years later. And I get the charges of hypocrisy, but if you don't take this head on and talk about this with others to say, wait a minute, these two things are different, then you do set yourself up for these charges of hypocrisy. But honestly, anybody who can't see that these are completely different things when a country is continuing to attack civilians in a neighboring country, I mean, one has to have a detailed explanation of it and not shrink from it.
let's not get bogged down in Iraq. I think Gaza is actually on many more people's minds than that right now.
Is that a better place to get bogged down in?
and I agree we shouldn't get bogged down there. The one thing I did want to bring up before we shift to an audience set of questions, and please prepare your questions for us. Matias, you of course you framed your argument around the shibboleth of the West versus the rest of the us versus them. We are in this moment, especially in this city, where there's a lot of focus on competition with China, on great power competition in general. While that is obviously the ways in which many people see things go, we are also in a kind of illiberal versus liberal moment everywhere. You think about our dear friends from the Netherlands, the party that won the most votes there in recent elections. You think about the election that may happen here, that will happen here in November, what could happen thereafter, the European parliamentary elections, the status quo that's settling in India, and go on. You can go on in the list. Would it be possible to have an illiberal rules-based order?
That's a great question. I guess it would, conceptually, it would be feasible. What's the name of the TV show that runs the counterfactual? What would have happened if Hitler had won the Second World War? The Man in the High Castle. That would be an illiberal international order, a set of rules, norms, and institutions, not centered around pushing for liberal ideas, but the opposite. But I don't think we're there, right? The West remains, if not preponderant, it's far more prominent in all aspects of power than China or Russia. And most countries of the world have been socialized in a set of rules that follows this historical evolution we've been talking about. My guess is that the best way to deal with the challenge is precisely to do what John just said. In the face of all these challenges, you need to double down on your commitment to international rules and norms, knowing full well that these will be the object of enormous dispute between countries. Another difference between Iraq and what Russia is doing now in the Ukraine is that in the case of Iraq, the US government went through the motions of trying to get authorization. It made a legal case. You can challenge the case, but a legal case was made. And that makes all the difference. Standing from the part of the world where I'm standing in, you're used to great powers doing as they wish. Oftentimes, the fact that you have great powers that need to go through the motions of international law to try and justify their actions is actually a positive thing. My core message is the West versus the rest story really weakens our ability to confront these challenges now, because confronting these challenges will require people from across the board to double down on the global legal order. And the global legal order will not and never was a place of consensus, of moral consensus. Because again, international law is a weapon at the hand of the states, but what we want is them to do their battle through those tools rather than through war. It's a minimalist expectation about what the world will deliver, but one in which the global legal order sits at the heart of it. And this is a global legal order, and it needs to be protected as such.
Bruce, John, any more quick reactions to what Matias just said? I do have one more question for you, Matias, before I turn to the audience. We've seen in the wake of the Russian invasion of Ukraine the kind of crystallization, the hardening of a geopolitical West, right? And then, of course, at the same time, and then certainly after the war in Gaza has unfurled in pretty hideous fashion, we've talked more concretely about the global South. You and I are both, I would say, global South liberals. But how, when we invoke the shorthand of the global South, what does it mean to you? I think the president of the ICG wrote a pretty good essay this week in Foreign Affairs, picking apart our usage of this term. You know, there are many countries in the global south that are more south than others, you know. And they, of course, have a whole discordant set of interests. The BRICS as a grouping is the brainchild of a British economist at Goldman Sachs. So what are we talking about when we say the global south?
This is a great question, because if you open the Financial Times, every other week there's a piece saying we should retire the concept of the global south. Assuming that when one uses that idea, one is implying that there is consensus among over 150 countries, would be as suggesting that the West is a cohesive form. All you have to do is listen to Emmanuel Macron and you will know that there's diversity within the West, enormous diversity within the West. So why would we expect otherwise with regards to the Global South? The one thing that the Global South does, and I'm not particularly defending this form, you know, in the past it was the third world, is that it speaks to a shared experience of being the underdog. Right? It speaks of an international system that is not anarchical in the sense that all states are equal because there's no supranational authority able to mediate conflict. It speaks of an international system that is very hierarchical. And I think there's something to that. And it seems to me that for many people who are born and grow up in countries that have the experience of being at the receiving end of a hierarchy, there's a sensibility that might be shared. That said, I would be very critical of the idea of the Global South, because isn't it the case that North and South coexist in most countries? I mean, look at what's happening in the United States. The experience with inequality and dispossession is enormous, and it translates into demographics that have a very hard time agreeing on what America's role in the world should be. So in many respects, North and South coexist inside countries. And, you know, oftentimes when I look at student protest in this country on the issue of Gaza, there's more commonality in views between these students and diplomats in countries of the Global South than between these students and other demographics inside the United States. So, like the West, the Global South is a construct that we use to try and summarize a broad phenomenon. And what that broad phenomena is an experience of inequality when you're at the bad end of that inequality. And that's all it does, and I wouldn't expect it to deliver more than that.
You invited me to respond to something, because I really agree with something you have said here. There are conversations that go on, say, between the legal advisors of Western countries and maybe Latin, South America, Africa, the smaller countries in Asia, but they're on technical issues about a treaty. You know, these big questions which really trouble people about, you know, hypocrisy and, well, why isn't you know, why are you lecturing me about not supporting the West and Ukraine when I raise Iraq? You know, our ambassadors are not trained. I mean, I cannot imagine a U.S. ambassador or a Dutch ambassador if you know, maybe I have 2 lines on that, but we'll rapidly change the subject. And there are answers to these questions when the other countries, you know, raise questions about hypocrisy or about the international rules, and, well, aren't these just Western rules? And so I think the point that you ended on of we have to have these conversations are extremely, extremely important.
We have a bit of time for questions, so the gentleman in the back, right there, yeah.
Yes, my name is Roger Cochetti. I'm an editorial contributor on technology policy for The Hill newspaper, and in a previous incarnation, I was the head of legislative and public affairs for a principal foreign affairs agency in the U.S. government. So my question sort of revolves a little bit around that. I think it's probably not productive to try to talk about the difference between international law and rules-based international order, because you're quickly going to get into too much philosophical, nor is it productive to talk about rules-based international order from my perspective, from my experience, on a global scale. The only way I can think about it is U.S. perspective on the issue of a rules-based international order. And I don't think it's unreasonable to say that we have spent trillions of dollars and there have been millions of lives lost to defend, from the U.S. point of view, rules-based international order, and politicians will refer to that. And I think I agree, there's no amount of money we shouldn't spend to defend. But on that issue, I wonder if any of the panelists would be willing to venture an answer to the question from a U.S. perspective. Who decides what a rule is in the U.S. perspective towards a rules-based international order? And secondly, more importantly, who decides that that point? So the question is, from a U.S. perspective, defending a rules-based international order, we will spend trillions of, and have spent trillions. Who decides what the rules-based international order is, and who decides what a rules-based international order is? Thank you.
Can I take that initially? The answers to that are pretty simple, actually. Inside the United States, essentially the U.S. government, and it comes down to essentially the legal advisor of the State Department or the Attorney General of the United States, if the Attorney General wants to overrule the legal advisor, who decides what the U.S. interpretation is of international law. That is our perspective. Now, that doesn't mean that other countries will agree. They often disagree. One of the things that we write about internally is this is our position, but we know that others may disagree or do disagree. Above that, who decides? I mean, this is the basic question that all of us who are international, this is the first question that Ona gets from her 1Ls at Yale is there really international law if it's not enforceable? And we do have various enforcement mechanisms. The International Court of Justice is the principal body for resolving international disputes. Some countries, like China, refuse to participate in international dispute resolution. The U.S. does, Russia does, the UK does, other countries do, but that's how disputes are resolved. And then ultimately, if a country ignores a ruling of the International Court of Justice, then it's up to the Security Council to order enforcement. But then we then know what the problem is there, is that any of the 5 permanent members of the Security Council can veto enforcement, and that's exactly what has happened in a number of conflicts over the last 20 years. But that's the way the system works.
The gentleman in the middle there. Thank you.
Thank you. I'm Leon Weintraub, retired member of the Foreign Service. Let me weigh in a little bit on this phrase, rules-based international order. What would you use to describe the workings in international affairs of the International Civil Aviation Organization, International Maritime Organization, the ITU for telecommunications, the UPU for universal postal systems? All these intermesh to have the world work simply and effectively as it does. It's not law. It seems to me there are rules and norms that people tend to obey. What would you call that system if not a rules-based international order?
I mean, I agree. Yeah, so, I mean, I think that this is critical. I mean, I think sometimes people, I appreciate your raising these more technical treaties, including the ITU, which is the oldest international agreement still in force. Sometimes people think of international law as exclusively being the UN Charter, but there's this extraordinary web of international agreements around the world that govern everything from, when you can put a stamp on an envelope and have it delivered somewhere, far, far away and totally across the world. And that's governed by the Universal Postal Union. You can pick up the phone and call somebody in another country, and that's governed by the Telecom Union. So there's this extraordinary system of interwoven international legal rules. And I think the question, I guess, for those who are critics of this idea of a rules-based order, and I take the point here that you all are not necessarily disagreeing with the idea, the value of what we're calling the rules-based order, but disagreeing more with the label. So I take that point. That's an important one. But you can't beat something with nothing. So like, what do you beat it with? If it's not, it's a sort of useful way of trying to articulate this idea that there's a set of rules that apply to all states and apply to all states equally. And if we're not going to call it a rules-based order, what are we going to call it? What is, I mean, I guess we can call it the international legal order, but is that really any better? I don't know. So I'm in agreement. I don't know if you want to say more, Matias.
And as quickly on sort of, in a sense, in both questions, like, you pointed out the United States expends treasure and risks lives in defense of certain parts of the order. One of the most important ways we do that is we deploy the U.S. Navy to enforce freedom of navigation globally, right? You cannot find a single phrase in any legal document that stipulates that the United States should be the guarantor of the law of the sea. That's not a legal concept. It's just a thing that we do. It's a very good thing that we do. It's foundational to growth in all sorts of countries. I'm incredibly glad we do it. And lots of countries, including China, by the way, profit massively from the fact that we do it. But it's not a legal concept. So my point here is that there are lots of things that we do in the world. Some of them are very important, very powerful, and legal, not legal, is not an adequate depiction of our character of action in the world, nor is legal, not legal, an adequate depiction of China's or Russia's action in the world.
So I would, maybe not a surprise, disagree with that. So, I mean, I don't disagree that there's nothing that says the U.S. has to maintain the rules-based global order and that it has to engage in these actions to try and enforce international law abroad. But one has to remember that what the U.S. is doing is enforcing the law by engaging in these, in sometimes overflights and freedom of navigation. And what is that law? Well, the U.S. is actually not party to the Law of the Sea Convention, but it has recognized it as customary international law. It's explicitly said that it's customary international law. The U.S. recognizes this binding on it and binding on all states in the world. And what the U.S. is doing when it's engaging in those freedom of navigation exercises is asserting that the law applies to everyone. It's asserting that the law is in fact effective. It's asserting that the law binds China, that the law binds the states that are refusing to abide by the obligations. The U.S. also recognizes that it's binding on the United States. So when the U.S. is engaging in these freedom of navigation exercises, it's doing so in compliance with international law. And it's doing so in order to enforce international law. And what's interesting to see is that international law has actually shifted on this question of law of the sea, because before the Law of the Sea Convention existed, the U.S. position was that the territorial sea was only 3 miles, in part because that's how close we had to get in order to be able to listen in to messaging with our submarines. And when the Law of the Sea Convention went into place and set a territorial sea of 12 miles, initially the United States was a persistent objector, but eventually agreed to comply with that and agreed to the 12-mile territorial sea, and now is engaged in the process of enforcing that through its freedom of navigation and ensuring that other states abide by those rules, particularly when it's more powerful states trying to break the rules against less powerful ones. And the U.S. is using its might to enforce those legal rules in order to ensure that states, in fact, can engage in freedom of navigation, that Iran, for instance, can't cut off one of the most powerful and important trade routes in the world, that China can't, in fact, declare that its control over the South China Sea and have that be effective. So what the U.S. is doing, it may not, in fact, it specifically says that what it's doing is enforcing the law when it's engaging in these freedom of navigation exercises. And I think that's a really important role that the United States plays in the world.
So we are right up against the clock, and I want to thank you very much. Unless Matias has any concluding thoughts, I think...
Just want to thank these wonderful panelists for sharing the podium with me.
Thank you all, and thank you to Brookings.
We have longer conversations.